Okay. Donnelly is here. On the record in the matter of the people of the city of Lansing versus Elena Lease, file number 23-010350 OT, council appearance.
Oh, I'm sorry. I didn't think it was Mr. Staples there. I didn't know if he was going to put his appearance on the record.
This is for sentencing.
Oh, okay. There was a question of restitution, so I didn't know if he was going to put. Your Honor,
okay, sorry.
Assistant Public Defender Sarah Donnelly, on behalf of the attorney of record John Lee, with the defendant Elena Lease, who is appearing separately by video.
No victims here. There's no victim, so I assume Mr. There was restitution on to provide info. Okay. You've never been in contact with your.
We were in contact with them. They said they were planning to appear this morning, and they have not appeared.
There's no one sitting out there?
No, there's literally no one.
Okay, I would first go down there and check. There was someone getting off the elevator, and they were looking and they looked lost, so they might be at the window.
Security. If they're talking to.
Okay. Let's see. You're all set. Are you now working or you are
No luck, Your Honor.
Okay, sounds good. Okay, restitution will not be entered at this time. You can make allocation.
Thank you, Your Honor. Ms. Lease is a caregiver in medical tech that provides for her younger siblings. So we just want to, and obviously she qualified for our services. We just want the court to consider that when setting fines and costs. Thank you.
The fine is $200. When can you make payment?
I can make a payment for $100 today, and I could make another payment when I get paid at the end of the month.
Okay, I'll note that here in the record. You can make payment by making payment online using your case number on the court website, or you can come up to the criminal traffic window and make payment in person, okay?
Okay, thank you, Your Honor.
Thank you. Do you have any questions at this time?
No, Your Honor.
Okay, you're all set.
Thank you.
You're welcome. On the record in the matter of the people of the city of Lansing versus Carol Vandermoor. File number is 23-00271. Council appearance.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Carol Vandermoor, who is appearing separately by video.
Is the date and time set for sentencing? I do have a pre-sentence report here. Dated for June 5th, 2023. Did you get a copy of that?
I have, Your Honor, and I have had an opportunity to review it with Ms. Vandermoor. We have no need for additions, deletions, or corrections.
Make our allocutions.
Thank you, Your Honor. We do agree with the pre-sentencing report that Ms. Vandermoor is a good candidate for a short term of probation, in which time the court can supervise her with a random and alcohol drug testing and have her provide proof of the alcohol highway safety program and MAD victim impact panel. I've already provided her the contact information for how to obtain these and complete these programs. And so I don't believe that there will be any issues with her on probation. So we just ask that the court follow the recommendations. And obviously, if there's any discretionary fines or costs that can be waived due to her indigency, we would also be requesting that. Thank you, Your Honor.
Your client wish to make a statement at all.
Ms. Vandermoor, or did you want to say anything?
No, ma'am.
Okay. I've had an opportunity to review the pre-sentencing report, the recommendation of probation, and I reviewed Ms. Vandermoor's prior criminal history, which was limited to nothing else. This is the first offense on this, but a relatively high blood alcohol content. It does state here that the assessment determined that she did not need treatment but could benefit from a highway safety class. I am going to order that she complete that. I'm going to order that Ms. Vandermoor, you are to take a highway safety program and the MAD victim impact panel within 90 days.
Okay.
Let's see. Because of that, I'm going to, instead of putting you on probation for 6 months, I'm going to start you off on 3 months. I believe that's sufficient time to get this taken care of. While on probation, you're not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm, ammunition, or weapon of any kind. You're not to possess alcohol, marijuana, or controlled substance without a valid prescription. You will be required to report for random preliminary breath testing and/or urinalysis testing, and you're responsible for the cost of that, okay?
Yes, ma'am.
You're not to be at any bars or nightclubs while on probation. Do you have any questions so far?
No, ma'am.
Okay, there is a $30 per month oversight fee that you would be responsible for while you're on probation. $75 crime victim rights fee that you're responsible for, $50 state minimum cost that you're responsible for. You owe the Lansing Police Department $537.11. for responding to the OWI. I'll waive discretionary fines and costs, and your total is $752.11. You'll be making monthly payments to get that paid in full and to remain compliant with your probation status, okay?
Okay.
Do you have any questions?
No, ma'am.
There is an advice of rights as to probation. It says you have been sentenced to the term of probation in the 54A District Court. The probation conditions have been individually tailored and are specific to address your assessed risks and needs. Except for domestic violence, criminal sex crime, and stalking or an offense where the defense of guilty but mentally ill was asserted, you may be eligible for early discharge from probation. You have the following rights. You have the right to request early discharge from probation once you have completed half the original term ordered by the judge. Your probation officer may, but is not required to, file a notice with the judge once you become eligible for early discharge. The probation officer must send to you and the prosecuting attorney a copy of the notice. The prosecuting attorney has 14 days after receipt of the notice to file any written objections to early discharge. You may request early discharge on your own from probation after meeting the following conditions. First, you have completed all the required programming, and B, you have not violated probation within the last 3 months. You must send a copy of your request to your probation officer and the prosecuting attorney. The prosecuting attorney has 14 days from receipt of your request to respond with any written objection to your request for early discharge. If a hearing is scheduled to address your request, you have the right to hire or retain an attorney to represent you. You do not have the right to a court-appointed counsel to represent you for a request for early discharge from probation status. Lastly, you may make your request for early discharge by completing a notice regarding eligibility of early discharge from probation. That's the MC 512 form. That form is located on the court's website. Do you have any questions about those rights?
No, ma'am.
Okay, any questions about your fines and costs or your probation requirements?
No, Judge.
Thank you. Any additional matters for the record, counsel?
No, Your Honor.
You're all set, ma'am.
Thank you.
You're welcome. I'm assuming the other citizens failed to appear.
Hold on, Morris.
Oh, he hasn't won. So it's not gonna run on the phone. On the record in the matter of the people of the city of Lansing versus L. Don War, file number 22-02948, council appearance.
Good morning, Your Honor. Ariana Ball requesting permission to practice pursuant to MCR 8.120 on behalf of attorney on record John Lee on behalf of Mr. Ward.
Permission is granted. Today is the date and time set for sentencing. We have a pre-sentence report. It's dated for May 3rd, 2023. Did you get a copy of that and was that reviewed with your client?
Yes, Your Honor. I have a copy and reviewed it with Mr. Ward yesterday. We have no additions or corrections to make.
Thank you. You can make allocution.
Your Honor, we agree to the pre-sentencing report of the probation with a possible substance abuse weekend program, random testing, and 25 hours of community service in lieu of any punitive measures in this matter would be appropriate. I believe it's important to note that Mr. Orr is currently taking active steps to better his life. He takes responsibility for his prior actions. He is bettering his life by taking up new hobbies and activities that do not revolve around his old life, such as basketball, running, and walking. He is currently freelancing for an independent cleaning service for employment while also scheduling and has interviews scheduled for next week for new employment. He has daily calls with his child and is working towards being a good foundational parent in their life. He has a good support system at home with his mother and is currently looking into local AA meetings and plans to join those groups. Therefore, Your Honor, I believe in this sentencing should allow Mr. Ward the ability to take responsibility for his actions while also continuing to better his life for himself and his family. Thank you.
Thank you. Does the client wish to make a statement?
Come again?
Yes. Did you wish to make your own statement today?
She pretty much hit every aspect on the in the matter. As far as the job search has been going, it's been a lot more difficult with me not being able to drive. So I was wondering if my driving privileges will be lifted or what that would be, because then I would be able to expand my search, and it'll probably be a lot easier to get around and stuff like that. And figuring that my mom's 69 years old and she's already doesn't know. So I mean, if I would be legal to drive, that would be wonderful. If not, I will continue my path. But yeah, I've been bettering my life by avoiding all of my past, and my mom has been a very good influence and helped me keep up. So that's about.
I've reviewed the pre-sentence report and the recommendation, as well as your prior criminal history, which was brief, but I do see one other conviction on there. Report opines that you would benefit from some judicial oversight. You need to attend a victim impact panel. It's recommended that you participate in random testing and then obtain employment. I think the recommendation is appropriate, so I will adopt it. Let's see. I will sentence you to a term of 6-month probation. While on probation, you're not to engage in any assaultive or threatening behavior. Do you understand that?
Yes, Your Honor.
Okay. You're not to purchase or possess a firearm, ammunition, or weapon of any kind. You're not to use, purchase, or possess alcohol or marijuana or any other controlled substance that you do not have a valid prescription for. Do you understand that?
Your Honor.
I'm sorry?
Yes, Your Honor.
Okay. You're going to be required to submit to random preliminary breath testing and or your analysis testing. You're responsible for the cost of that, okay?
Yes.
Okay, you're not to be at any bars or nightclubs while on probation. I am going to require that you attend a victim impact panel within 90 days and provide verification to your probation officer on an order that you complete 25 hours of community services. You're not employed. I'm not giving you 180 days to do that. I'll give you 90 days to do that. Let's see here. And you need to obtain employment and provide evidence of your attempts to obtain employment to probation. Do you understand that?
Yes, Your Honor.
As to fines and costs, there's a $75 crime victim rights fee that you're responsible for, plus a $50 state minimum cost that you're responsible for. You owe Lansing Police Department $696.88 for responding to the OWI call. I'll waive discretionary fines and costs at this time. Total fines and costs, including probation oversight fees, are going to amount to $1,001.88. You'll be required to make monthly payments on that, okay?
Yes, Your Honor.
You have any questions about your probation status or your fines and costs?
No, just my driving. Will I be legal to drive?
You have to take that up with Secretary of State. This is not suspending your license. You have to take it up with Secretary of State, okay?
Okay.
My order is not suspending your license.
All right. Thank you.
Okay. Is there any other questions?
No, Your Honor.
Okay, I have a felony complaint here. People of the state of Michigan versus Eldon War, file number is 23-01569FY. The complaint alleges, sir, that on or about April 10th, 2023 at 5700 Annapolis, City of Lansing, Ingham County, State of Michigan, that you did allegedly, contrary to law, commit the act in count 1 of home invasion, first degree. It alleges that you did break and enter or did enter without permission a dwelling at 5700 Annapolis Drive, and while entering, present in, or exiting, did commit a larceny and or assault, and while entering, present in, or exiting the dwelling, Tanisha Dankenbring was lawfully present therein, and that this was done contrary to Michigan Compiled Law 750.11A2. That's a felony. The maximum penalty is 20 years in prison and or $5,000 in fines. A consecutive sentence may be imposed for any other conviction arising out of the same transaction. There's a count 2 of interfering with an electronic communications. The allegations is that you did willfully and maliciously prevent, obstruct, or delay by any means the sending, conveyance, or delivery of an authorized communication by or through a cell phone, and that this was done contrary to Michigan Compiled Law 750.5405A. That's a felony with a maximum penalty of 2 years and or $1,000 in fines. There's a count 3 of domestic violence, alleging that you did make an assault or assault and battery upon a Tanisha Dankenbring, an individual with whom you had a child in common, or a resident or former resident of your household, or an individual with whom you had a dating relationship, contrary to MCL 750.812. Restitution may be ordered as this offense may have resulted in damage to another individual's property, physical injury, or death to another individual. That's a misdemeanor. Maximum penalty is 93 days in jail and or $500 in fines. A consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Do you understand your rights? I'm sorry, do you understand the charges and the maximum penalties attached?
Yes, Your
Okay. You have the following rights. You have the right to be represented by counsel. If you cannot afford to hire an attorney, you have the right to make a request to have the public defender's office represent you at the expense of the public. You are represented by the public defender's office. On your current matter, I'll note here you're requesting court-appointed counsel in the new matter. Okay, sir?
Honor.
Ms. Donnelly, does he have to do a new intake?
Yes, actually, I will do a new intake. His last one we had was from November.
Okay, sounds good. Okay, and Mr. Warrior, the right to remain silent. Anything that you say and anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, we'll set this for a trial. You have the right in this matter, because you're being charged with a felony, to have a preliminary examination. You have the right to have that preliminary examination now within 21 days of today's date, because today's the date that I'm arraigning you. At the time of the preliminary examination, you have the right to have the prosecution meet their burden, which is to establish that they have sufficient probable cause. So they have to establish that they have sufficient probable cause, that a crime was committed, and probable cause sufficient to charge you with this crime in order for this matter to proceed to a trial. You have the right to have a trial, and you have the right to a jury trial. At the time of trial, you have the right to the presumption of innocence. So you're innocent until proven guilty. You have the right to require the prosecution to prove each element of the charges being brought against you beyond a reasonable doubt at trial. You have the right to remain silent at trial and not have silence be used against you. You have the right to see, hear, or question any of the witnesses the prosecution intends to call. You have the right to call your own witnesses or present evidence that you believe further a defense to these charges. Do you have any questions so far?
Honor.
Okay, you have the right to be granted a bond pending this matter, and we'll address your bond at the end of this. Let me make sure we still have an accurate home address and contact information for you. For the purposes of today's arraignment, I am going to enter a plea of not guilty on your behalf, okay?
Okay.
Okay, you're currently scheduled to have a probable cause conference before Judge Stacia Buchanan. It's going to be Thursday, June 22nd, 2023 at 8:30 in the morning. You can't appear via Zoom, okay?
Okay.
Okay, your preliminary examination before Judge Buchanan is in person. That's going to be June 29th, 2023 at 9:30 in the morning, okay? Again, that one is in person. Do you have any questions about your dates at this time?
You said the 22nd.
Yes, June 22nd, and then Thursday, June 29th.
And they both are in person?
No, you can appear for your probable cause conference, which is the June 22nd date. You can appear via Zoom. Your preliminary examination, you must appear in person, okay?
And that one's the 29th.
June 29th.
Okay.
And these dates will be mailed to the address that we have on file. We have 5700 Annapolis. Is that still accurate?
No,
Okay, what is your address?
it'll be 929 North Pine Street.
Say that again.
929 North Pine Street.
Your connection is bad.
929 North Pine Street.
Okay, in Lansing,
Yes,
there's an apartment.
yes. Apartment B.
We can't hear you. Your connection is bad. Say it again. Say it again.
B?
Apartment B?
Yes. Correct.
Okay. What's the matter? B like boy.
Correct. Yes.
Okay, okay. And what's your phone number?
7-214.
We're gonna need those last four digits. And you know what? You're gonna need to appear for all your court dates in person from now on, because you don't got a good signal,
Okay.
okay? Give me those last four digits again.
3770.
Okay. When did your address change?
About just over a month ago.
Okay, you know it's your responsibility to update the court and your attorney with the new address when you change it?
I was on. Yeah, it just officially went through. I just got it in the mail.
Okay, you need to make sure you update your address so that we have the correct address to send your paperwork to, okay?
Okay.
Okay. Set your bond at 2,500 personal recognizance. While out on bond, there's a no contact order in place for the protection of the alleged victim, Tanisha Dakenbring. You're not to have contact directly or indirectly with her. Do you understand?
Correct. Yes, Your Honor.
You're not to be within 1,500 feet of wherever she is. Do you understand?
Yes, Your Honor.
Okay, you cannot have third-party contact. Do you have any questions about what third-party contact might mean?
No, Your Honor.
Okay, you need to make sure you appear to all of your court dates on time while on bond. You're not to use, purchase, or possess alcohol or drugs without a valid prescription. Not a problem because you're already on probation now, correct?
Correct.
Okay, you're not to engage in any assaultive or threatening behavior. You're not to travel outside the state without prior approval of the court. You're not to possess a firearm or any other dangerous weapon. You need to report to pretrial services within 48 hours of your release. You'll be reporting to them weekly, okay? You have any questions?
No, Your Honor.
Okay. Any additional matters on the city file or on this file, counsel?
Ms. Ball, you want to finish that up?
No, Your Honor. Thank you.
You're all set, Mr. Ward.
All right, thank you.
You're welcome.
Your Honor, could you put him in a breakout room with Ms. Ball so that she can review him for the next case?
Yes. Can someone take that up, please? They make sure they send his stuff to the right address. All ours on our list, yeah. Who's in the jail?
Yeah, hello,
What's your name?
Jeffrey Cook.
Okay. Does he have an attorney? That's a show cause.
I'm his attorney, Your Honor.
Okay. Open that.
You're all together.
No, I mean on the docket.
It was at like 10:30.
Okay. He's on right now for a show, so. Okay, you can hang tight. Lopez Hernandez. On the record in the matter of the people of the state, I'm sorry, the city of Lansing versus Jose Lopez Hernandez, file number 22-03345. Council appearance.
Matt Staples for the city of Lansing.
An assistant public defender, Sarah Donnelly, on behalf of the defendant, Jose Lopez Hernandez, who is appearing separately by video.
Today was the date that we reset pretrial. Negotiations were still pending at the last pretrial, and defendant needed to consult with an attorney about immigration implications. How are we proceeding at this time?
Your Honor, Mr. Lopez Hernandez has consulted with an immigration attorney, though he wasn't provided or offered further services from the immigration center. I believe Mr. Staples and I agree that if we can, to a term of a deferred sentencing in sobriety court, I believe he'd be a good candidate. So we'd be asking for a 30-day adjournment so that I can get him screened in East Lansing.
July 18th at 9 a.m.
July 18th at 9 a.m. Thank you, Your Honor.
No problem. Any additional matters for the record today?
Nothing for the city, Your Honor.
And nothing for defense. Thank you.
You're all set, sir.
Thank you.
You're welcome. On the record in the matter of the people of the city of Lansing versus Sylvia Montano, file numbers 22L2740841 and 842. Council appearance.
Matt Staples for the city of Lansing.
An assistant public defender, Sarah Donnelly, on behalf of the defendant, Sylvia Montano, who is appearing separately by video.
Thank you. Today was the date that we reset these hearings. Ms. Montano was waiting for a decision from Secretary of State. How are we proceeding?
Your Honor, Ms. Montano was denied restoration of her license. They did offer, I believe that she would have another opportunity in 6 to 12 months, but at this time, we've appreciated the court's patience in allowing Ms. Montano this time to seek restoration, and Mr. Staples has offered that she can plead guilty to an added count of allowing a suspended person to operate, and the city would dismiss the no ops and the disregarding of a traffic control device, which I believe Ms. Montano would accept.
Ms. Montano, is that correct?
You're muted.
You're muted, ma'am.
Yes, Your Honor.
Okay, if you want to accept, please raise your right hand. I can't see you though.
Oh my goodness. Just.
Okay, please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, Your Honor.
If you can put your hand down. Ma'am, you have the following rights. In this matter, you have the right to proceed to a trial. I am going to mute you because there's some feedback coming through. Okay, you have the right to a trial, and you have the right to jury trial. At the time of trial, you have the right to be represented by counsel. You have the right to the presumption of innocence. So you're innocent until proven guilty, and you have the right to have the city bring sufficient evidence to prove each element of the charge being brought against you beyond a reasonable doubt at trial. At the trial, you have the right to remain silent, not have silence be used against you. You have the right to cross-examine any of the witnesses that the city intends to call. You have the right to call your own witnesses or present evidence that you believe further defense to the charge being brought against you. Do you have any questions about those rights? You're muted.
No, Your Honor.
All right, you're willing to waive those rights in order to plead to the amended charge of allowing a suspended person to operate a motor vehicle?
Yes.
Okay, anybody threatening you to get you to waive your rights today?
No, Your Honor.
Any promises being made to you in exchange for you waiving your rights and pleading guilty?
No, Your Honor.
And are you pleading guilty to the amended charge because you believe you're guilty?
Yes.
Okay, as to the amended charge of allowing a suspended person to operate, do you plead guilty, not guilty, or stand mute?
Guilty.
I have a factual basis, please.
Thank you, Your Honor. Ms. Montano, on August 9th of 2022, were you operating a vehicle upon a highway, that being South Pennsylvania at or near Healthcare Drive in the city of Lansing, Ingham County, state of Michigan?
Yes, I was.
All right, and at that time, that you were operating that vehicle, was your license revoked?
Yes.
All right, and you still do not have, right now, you don't have a valid license.
Correct.
All right, Your Honor, I have no further questions.
Thank you. Any questions for you, Mr. Staples?
Nothing for the city, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea and find your plea to be made freely, voluntarily, and intelligently. Your fine is $200. When can you make payment?
I can make a payment today.
$200 in full? Okay, I'll note that in the file. You can make payment by coming up in person and to the criminal traffic window, or you can log on to the court website and use your case number and make a payment online that way, okay?
Is the court website on the paper, on the court papers? I don't.
It should be at the bottom of your court paperwork.
I'll just make it by window.
Okay, sounds good. Thank you. You're all set.
Thank you very much. Thank you for the court's time and patience.
No problem. Okay, Stephen Hirman did not appear.
And I hadn't, our office hadn't had any contact with him recently.
Not issued search warrant. They didn't put Robert Williams downstairs? Yeah. Oh, okay. Sure. I see Dominic Salazar.
Yes, Your Honor, I'm here.
Okay. Ms. Donnelly, are you ready on his matter?
Yes, I am, Your Honor.
We're on the record in the matter of the people of the city of Lansing versus Dominic Salazar in file number 23-00201. Appearance for the record.
Matt Staples for the city of Lansing.
An assistant public defender, Sarah Donnelly, on behalf of the defendant, Dominic Salazar, who's appearing separately by video.
Oh, this was a reset. I have a note here that the defendant was to plead guilty to an added count 3 of impaired, but he needed to contact his probation officer to see if that would be an issue with his probation status. How are we proceeding?
Your Honor, Mr. Salazar and his probation officer have discussed it, and it doesn't seem like it'll be an issue considering his probation officer considers this happening before he was on probation. So it shouldn't be a problem with him taking the offer, in which Mr. Salazar does want to do today.
Okay, that's correct, Mr. Salazar.
Yes, Your Honor, that is correct.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
Okay, you can put your hand down. I'm gonna advise you of your rights, and you have the right in this matter to proceed to a trial. You have the right to a jury trial. At the time of trial, you have the right to the presumption of innocence, so you're innocent until proven guilty. You have the right to require the city to prove each element of the charge being brought against you beyond a reasonable doubt at trial. You have the right to remain silent at trial and not have silence be used against you. You have the right to confront, question, or cross-examine any other witnesses that the city intends to bring against you, and you have the right to call your own witnesses or present evidence that you believe further the defense to the charge being brought against you. Do you understand those rights?
Yes, Your Honor.
And you're willing to waive those rights today in order to enter a guilty plea to add count 3 of impaired?
Yes, Your Honor.
Okay. Anybody threatening you to get you to waive your rights today?
No, Your Honor.
Any promises being made to you in exchange for you waiving your rights and pleading guilty to the amended charge?
No, Your Honor.
Okay, and you are on probation at this time. You're not on
Yes.
parole, correct?
Not parole, just probation.
And you've already discussed with your attorney how that might implicate your probation status, and at this time, you do not believe that's a problem, correct?
Correct.
And then you also understand that a guilty plea could result in a conviction that you may need to report to your current employer, or you may need to put a conviction on a future job application.
Yes, Your Honor, I understand.
Okay, and then also a guilty plea could have ramifications or an impact on any travel or immigration status that you may be seeking. Do you understand that?
Yep, I understand.
Okay. As to the amended charge of operating while impaired, how do you plead?
Guilty, Your Honor.
And are you entering a guilty plea because you believe you're guilty?
Yes, Your Honor, I do.
Okay, factual basis.
Thank you, Your Honor. Mr. Salazar, on March 1st of 2022, were you operating a vehicle on a highway, that being 1526 South Cedar Street in the city of Lansing, Ingham County, state of Michigan?
Yes, Your Honor, yes.
And before you were operating that vehicle, had you been consuming alcohol?
Yes, ma'am.
All right, and you knew it was alcohol when you were consuming it, correct?
Yes, ma'am.
All right, so when you are operating the vehicle on South Cedar in the city of Lansing, do you dispute that? Well, let me ask that again. You were stopped by the Lansing Police Department, correct?
Yes, ma'am.
Or you not stopped, but
No, I wasn't
they
stopped.
did arrest you.
Yes, I was arrested. I wasn't stopped, but I was arrested.
And they took a blood sample, correct?
Yes.
All right, and do you dispute that when they took your blood, at the time they took your blood, it was the blood alcohol content was 0.114 grams of alcohol per 100 milliliter of blood?
I haven't read the paperwork in quite some time, but I'm pretty sure that's what it was.
All right, and you don't dispute that you were at above 0.08 or greater when you were operating the vehicle, correct?
Yeah, I know I was way over the limit, and that's why that's why I know I'm guilty, and I'm fessing up to right my wrong.
All right, Your Honor, I have no more questions.
Any questions from the city?
Nothing from the city, Your Honor.
I'll accept your plea. I find your plea to be made freely, voluntarily, and intelligently. The sentencing date is going to be August 8th, 2023 at 8 o'clock in the morning. Why is it at 8 o'clock in the morning? Oh, it's 8:30. Thank you. It's at 8:30 in the morning.
Okay, August 8th, 8:30.
That's correct. Prior to
All right.
sentencing, you need to have a pre-sentence report completed. So you need to report to our probation department no later than 10 o'clock this Thursday, okay?
10 o'clock, okay. Where the probation department is at the 54A.
That's correct.
All right, so 54A, no later than 10 o'clock Thursday. Okay.
That's
Sorry,
correct.
I didn't have a pencil handy. I actually flipped a ATV the other day, so I had my leg up getting my leg iced. All right, 10 o'clock.
Okay, yeah, I noticed the injury to your forehead.
Yeah, we tuned up an ATV at my brother's house the other day and got it going so we could do some dune riding. And it didn't go so well in my favor, as you can see. No, we were playing
Gotta
around
be
with
careful
it.
with that cranium, sir.
Yes, I really wish I had a helmet on, but between my ankle and my head, I don't have a concussion and I didn't break a bone. So it's painful, but it could have been worse, but I will no longer ride anything without a helmet. All right, so I think I got it all written down. Okay. So no later than 10 a.m. and then 8:30
On Thursday.
Yep, on Thursday.
So they're gonna get you all set up for your pre-sentence report. You also need to undergo a substance abuse assessment, and they'll provide a recommendation to the court. We'll see you on August 8th at 8:30 for your sentencing, okay?
Yes, ma'am.
Do you have any questions at this time?
I think I am okay. I do not want to waste any more time. I just wanted to make sure I have all my information written down and let you proceed with the rest of your day.
Thank you, sir.
Yep, I got it all written down. Thank you very much. If I have any other questions, I'll get a hold of my attorney. Thank you very much.
Wonderful. Have a good one.
You as well.
This is Mr. Eames. Okay, I have Mr. Eames in the courtroom. Do you need to speak with him?
Just briefly, Your Honor.
Okay, give me just a moment. Do we have everybody else taken care of? Yeah, okay, that works. You were here on compliance. Kip Schultz.
Yes, Your Honor, is he available?
He's not here on Zoom. Let's see who Lisa Michelle is. I think that this is probably Lisa Evans, so. Sorry.
We can proceed.
Ma'am, what's your name?
Lisa Michael.
Did you have another name?
Oh, I'm sorry. It was Lisa Evans.
Very good, thank you. Sarah, I just put them in the breakout room.
This makes no sense.
Do you know who this is in the moto? No. Oh, okay, we'll do it next. We're on the record in the matter of Kip Schultz versus, I'm sorry, City of Lansing versus Kip Glenn Schultz. File number is 23005021. Council appearance.
Good morning, Your Honor, Assistant City Attorney Lynn Williams, appearing on behalf of the City of Lansing.
When was the date and the time that was set for a code compliance hearing? It's like there was an order that needed to be served on him and give him sufficient time to respond. I think we addressed that the last time and you did get that sent out.
Yes, we did. I haven't heard spoken hour before officer, he spoke with Mr. Schultz, and my understanding that he was supposed to appear today. I'm not sure why he's not here, but he's aware of the order, and my understanding also that he is working on fixing the violations. So I would like to ask the court for adjournment for 45 days to allow him the time to do so.
Okay, could this possibly be him? Okay, I'm not sure that. Can you spell your name for the record, sir?
STOCKENAUER.
Okay, you need a 45-day adjournment.
Yes, Your Honor.
August 8th at 9 August 8th at 9 a.m. Any additional matters for the record?
No, Your Honor, thank you.
Thank you, you're all set. Okay. Okay, what's your name, sir, on the Motorola?
Dennis.
Dennis Cates.
Yes.
Thank you.
You're welcome.
Court has the pretrial and
Your Honor, if Mr. Cates and I could be placed in a breakout room.
I'm sorry. Okay, you're already in a breakout room. We'll add him to the room.
Okay.
Okay, and Mr. Cook, you can hear me, correct?
Yes, Your Honor.
Okay, you do have a pretrial, but I'm gonna go ahead and address your two show causes. The people of the City of Lansing versus Jeffrey Cook, file numbers 23L2780481 and 82, set for show causes because he failed to appear in court back on May 16th. And so on May 18th.
I was in jail. Oh, wait, no, May?
Yes,
Yeah,
last
I was
month,
in jail
May.
here. I was in jail here.
When were you placed in custody at the jail?
The 17th of May.
Okay, but you didn't appear on the 16th to court.
I didn't know I had a court date on the 16th.
Okay, well, your failure to appear, because you got it, says you received a ticket back on April 25th, 2023 at 3:57 in the morning at the area of South Pennsylvania in Kalamazoo. It was for improper turn, no proof of insurance, and a failure to
Yes.
display license.
Yes,
Okay, so there was default judgments that was entered when you failed to appear. On the no proof of insurance, you owe $175. And on
Alright.
the improper turn, you owe $155. But how long are you in custody for, sir?
I'm serving, I haven't even been sentenced yet, but it's a disorderly conduct ticket. And after that, I plan on sticking around for a little bit longer to clear up all this stuff with the courts and then moving back to Illinois.
So you're being held
I have
on,
an address. Once I get released, I do have an address to go to here in Lansing.
okay, I think on your failure to display license, you get your mom address that you gave, and then you did give an address on Long Boulevard for Lansing.
Yes, I have that one. I also have another one. It's 2900 Eaton Rapids Road in Lansing. It's a girlfriend of mine that I'll be staying with. So.
Okay. And so you're currently being held in the custody for a disorderly?
Yes,
And you don't have a court date for that?
July 16th.
You don't see anything else on this? He has other, it's only. It's on his ticket. No. Okay, when do you intend to make payment on these?
As soon as I'm released. I have $0 right now, but I can make a payment as soon as I'm released.
Okay, you say you're gonna be your sentencing is July 16th?
Yeah.
Okay, we'll reset this for after July 16th.
Thank you.
You're welcome. And then you have one more case that you need to talk to your attorney on, okay?
Okay.
July 25th.
Now I have a question. Are these charges gonna hold me here once I'm released on my other case, or are you guys gonna let me go so I can make a payment?
This is show cause, so you aren't being held on this. We just
Okay.
set it and had you read it since you were in the custody, but no, you're not being held on that. And then your other case, the failure to display a valid license, you received
Yep.
a personal recognizance bond.
Yes. Okay. May I speak with my public defender?
You may. Ms. Donnelly, are you representing him?
Yes, Your Honor.
Okay, we'll put him in the private meeting room in just a minute. Let me get Mr. Ian's taken care of. Are we ready on him?
Yes.
On the record in the matter, the people of the city of Lansing versus Robert Eames, file number is 22-00027, council appearance.
Matt Staples for the city of Lansing.
An assistant public defender, Sarah Donnelly, on behalf of the defendant, Robert Eames, who is appearing in person.
Today's date set for a pretrial and a no insurance. How are we proceeding?
Your Honor, at this time, the city is willing to offer an added count of a civil infraction, no proof of insurance. Mr. Eames would admit responsibility to that, and in exchange, they'll be dismissing the not having security or insurance on the vehicle.
Okay, is that correct? You want to admit responsibility?
Yes, ma'am.
Okay. You have valid insurance?
I don't have a vehicle anymore.
Okay. The fine is $145. When will you be able to make payment?
When I get out of jail.
Okay, when is that?
I have no idea.
What are you being held on, a bond or is you serving a sentence?
I go to court to get sentenced, July 17th for, possession or usage and, carrying a concealed weapon. I had a knife in the back, sitting on my back seat that I didn't know was there.
What's your address?
3421 Rayburn.
Lansing? The phone number?
517-666-6468.
We will refer this to collections and you can make a payment plan after you're released. You're all set.
Thank you.
You're welcome. Okay. Ms. Donnelly needs to meet with Mr. Ms. Donnelly, I'll put him in room 1.
Thank you.
No problem. Are we ready on Mr. Cates?
Yes.
No, Your Honor, if I could briefly talk to the city attorney, Mr. Staples, briefly.
Mr. Staples, I'm gonna add you to room 2.
Very good, Your Honor.
Thank you.
Your Honor, can I request being put in the breakout room with Mr. Staples and Ms. Ball?
I moved you there. Are we ready on Mr. Cates?
Yes, Your Honor.
What about Mr. Cook?
Yes, Your Honor.
Okay. Mr. Cook, can you hear us?
Yes.
Okay, can you, Mr. Cook, if you're in there, you need to stand up so that the light comes back on. And move, we have to make movement. Is he still there? It looks like he's right there. Mr. Cook, can you hear me? Mr. Cook might not be in there anymore.
Oh.
Hi, who's in the jail? Mr. Cook might not be there anymore. I'm not sure if they're gonna put him back on there because he's actually scheduled at what time? 10:30? Maybe they'll put him back on at 10:30. Oh, well, that's problematic because he's not been addressed. We need to see if they can put him back in there. Okay, and last, Ms. Dolly, were you just asking to reset that?
No, he was going to plead his charge.
I wonder why they did it. He didn't know his deputy died. Okay, we'll see if they'll put him back on. We're on the record in the matter of the people of the city of Lansing versus Dennis Wayne Cates, file number 23-01272 and 23L2770162. Council appearance.
Matt Staples for the city of Lansing.
Good morning, Your Honor. Ariana Ball requesting permission to practice pursuant to MCR 8.120 on behalf of Mr. Cates.
Today's the date set for pre-trial. I have a driving while license is suspended, then it's up for explanation hearing on a no insurance. How are we proceeding?
Your Honor, after briefly talking with attorney Matt Staples and Mr. Cates, we have agreed on a possible 30-day adjournment in this matter for Mr. Cates to make his way to the Secretary of State and to figure out how the steps he needs to take to obtain a valid license.
Okay, so he is gonna need 30 days to figure out what the attempts are, or is he gonna make attempts during those 30 days?
Make attempts during those 30 days, Your Honor.
July 18th at 9. Do you have any questions today, Mr. Cates? Do we have his fingerprints? We need your fingerprint, so you gotta come in this week and get it taken care of.
Okay, I will.
Thank you. Any additional matters for the record?
Nothing for the city, Your Honor.
No, Your Honor. Thank you.
Thank you. You're all set, Mr. Cates.
Thank you.
Thank you. I don't know why he wouldn't tell them that he was waiting to do a plea. Okay. I think it's Salazar. Make sure. Might be in Eaton County, no rip prepared. That's Escuchia. This Escuchia needs to be written, so we'll reset that. We're not sure if he's still in Eaton.
Your Honor, when I called yesterday to the jail, I didn't hear that he was there anymore, but I don't know when he was released.
Okay, we'll follow up on that. If he was released, I'll issue a bench warrant. Okay, Mr. Cook, can you hear us?
Yes, I can.
Okay, we're on the record in the matter of the people of the city of Lansing versus Jeffrey Cook in file number 23L2780483. Appearance for the record.
Matt Staples for the city of Lansing.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant, Jeffrey Cook, who's appearing separately from the County Jail.
Thank you, Mr. Cook. Today was the date that was set for pretrial on a failure to display a valid license. We did meet with counsel. Counsel, how's he proceeding?
Your Honor, I have gone over the ticket with him. At this time, he'd be pleading as charged.
That's correct, Mr. Cook.
Yeah. Yes, Your Honor.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
Thank you. You can put your hand down. Mr. Cook, you have the right in this matter to proceed to trial. You have the right to a jury trial. At the time of trial, you have the right to have the city prove each element of the charge of failing to display a valid license.
Yes,
You have the
Your
right to
Honor.
have them prove each element beyond a reasonable doubt. You want to give up that right to have them prove each element beyond a reasonable doubt?
Yes.
So that means you're giving up your right to the presumption of innocence. So you're innocent until proven guilty, and you have the right to cross-examine any of the witnesses they intend to call. You have the right to call your own witnesses or present evidence at trial you believe would further a defense to this charge. And you also have the right to remain silent and not have silence be used against you. You want to give up all of those rights today in order to plead guilty?
Yes, Your Honor.
Anybody threatening you to get you to plead guilty?
No.
Any promises being made to you in exchange for a guilty plea?
No.
As to the charge of failure to display valid license, how do you plead?
Guilty.
And are you pleading guilty because you believe you're guilty?
I'm pleading guilty because I know I'm guilty.
Okay, that works. Factual basis.
Thank you, Your Honor. All right, Mr. Cook, on April 25th of 2023, were you operating a vehicle on a public highway, that being upon South Pennsylvania Avenue at or near East Kalamazoo Street in the city of Lansing, Ingham County, state of Michigan?
Yes, I was.
And at that time and place, while you were operating that vehicle, did you have a valid license?
No, I did not.
All right. And is your license at this point still not valid?
Yes, it is not valid.
All right, Your Honor, I have no further questions.
Any questions from you, Mr. Staples?
Nothing from the city, Your Honor.
I'm satisfied with the factual basis. I'll accept your plea. Find your plea to be made freely, voluntarily, and intelligently. I think you've been in custody since the time you were arraigned on May 18th. Is that correct, sir?
Yes, Your Honor.
I'll credit you time served. You're all set.
Thank you.
You're welcome.
Good to go?
You're good to go.
Thank you, Your Honor.
You're welcome. That jail video, and then that's a there. Does someone need to meet with Mr. Conley?
Yes, Your Honor, I do.
Okay. Okay, Ms. Evans, do you have an attorney representing you?
No, Your Honor, I do not.
Okay, on the record in the matter of the people of the city of Lansing versus Lisa Marie Evans in file number J036187OD. For appearance, please.
Your Honor, would you like my appearance in this matter?
Absolutely.
Matt
You have
Staples,
to-
on behalf of the
Do you
city of
have this
Lansing.
file? Do you have this file?
Yes, it's the application to set aside the conviction.
Absolutely. The prosecutor attorney must always appear and they must give an opinion as to whether or not they're objecting or not.
All right. The city in this matter, Your Honor, has no objection, would stand mute and rely on the discretion of the court.
Thank you. I do have a response, I believe, from the Attorney General's on this application to set aside an operating while intoxicated from September 29, 2003. There's no objection from the Attorney General's office. Ma'am, what have you been doing since the time of this incident?
Your Honor, I have actually gotten my life together when it comes to this situation. I have been in recovery for almost 20 years. I have obtained my GED. I got married in 2014. I bought a home with my husband. I have my own cleaning business that I, go to Monday through Friday. I have gotten my charges from Maryland, all of them expunged. They are no longer a part of my record. And I'm also getting ready to start school in the fall of August in order to get my AA degree to study paralegal major. My major is paralegal.
Very good. That sounds like you used the last 20 years to be productive. I'm looking over your prior criminal history. I only see this in one other incident in the state of Michigan, at least. I don't believe that you would warrant any additional rehabilitative or educational programs. It looks like you've done what you needed to do. And I believe that your request and application is in the interest of public welfare and warrants the granting of the setting aside of the conviction. So I will grant that request. And
yes, ma'am. Thank you very much.
thank you, and congratulations and good luck to you.
Thank you. You also.
Thank
Have
you.
a good day.
Same to you. Okay, you're here for motion hearing. Correct.
Yes, Your Honor. I'll be right down for that, Your Honor.
Okay, sounds good. Nope. Never seen Trey Dupard here. Did I miss somebody? James Fields didn't appear. James Dupard failed to appear. Sam Jones, the fourth. Failed to appear. What's going on at 10 o'clock? Dwayne Williams failed to appear. 10 o'clock, 7 more interesting. Okay, let's see. I can bring Mr. Conley back. Mr. Bonds is downstairs. It should be. Okay. Right. Mr. Conley, can you hear us? Did they remove him too? No way. Mr. Conley, are you there? Okay, Ms. Donnelly, what was the expectation with Mr. Conley today?
He had a amended offer for no operator's license possession that he wanted to take.
What are they doing in Union County today? Sounds good. Well, see if Union County wants to put him back on.
Nice to meet you. Yeah.
Okay, Mr. Conley, can you hear us? Okay, very good. We're on the record in the matter of the people of the city of Lansing versus Benjamin Conley, file number 23L2773241 and 23-01377. Council appearance.
Matt Staples for the city of Lansing.
An assistant public defender, Sarah Donnelly, on behalf of the defendant, Benjamin Conley, who is appearing separately from the Ingham County Jail.
Okay, today was the date and time set for pretrial on a driving unlicensed and an explanation hearing on a stop sign violation. How are we proceeding, council?
Your Honor, at this time, it's my understanding that Mr. Staples has offered that Mr. Conley can plead guilty to an added count of operating without or not displaying a valid license. I believe that they would dismiss the misdemeanor and the civil, the unlicensed and the civil infraction.
The failure to display valid license, is that what you're talking about?
Yes, that would be the ad account, yes.
Correct, Mr. Staples?
That's correct, Your Honor.
Dismiss the sign.
That's correct. And amend to allowing.
Allowing is different. If you want to do allowing, I'm fine with that.
Is it allowing or is it failure to display a valid license?
I'm sorry, Your Honor, confused. It is failing to display a valid license.
Okay, sounds good. Okay, and Mr. Conley, you want to plead guilty to failure to display a valid license?
Yes, ma'am.
Can you raise your right hand? You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury. I can't hear anything.
Yes, ma'am.
Okay, thank you. You can put your hand down. In this matter, sir, you do have the right to a trial and you have the right to jury trial. You have the right to the presumption of innocence, so you're innocent until proven guilty. You have the right to require the city to prove your guilt by proving each element of the charge being brought against you beyond a reasonable doubt at trial. You have the right to remain silent at trial and not have silence be used against you. You have the right to confront and question any other witnesses that the city intends to call, and you have the right to call your own witnesses or present evidence at trial that you believe further defense to this charge. You're willing to give up those rights today?
Yes, ma'am.
Anybody threatening you to get you to give those rights up? I don't know what's going on with their Zoom. Anybody threatening you to get you to give those rights up?
No, ma'am.
Any promises being made to you in exchange for you waiving your rights and pleading guilty?
No, ma'am.
Okay, and are you entering a guilty plea to the amended charge because you believe you're guilty?
Yes, ma'am.
Okay, as to the amended charge of failure to display valid license, how do you plead?
Guilty.
Have a factual basis, counsel.
Thank you, Your Honor. Mr. Conley, on April 28th of this year, were you operating a vehicle upon a public highway, that being Northrop and at or near Kurt in the city of Lansing, Ingham County, state of Michigan?
Yes, ma'am.
And at that time and place, when you were operating that vehicle, did you have a valid license?
No, ma'am.
All right, and was it, you were pulled over by the Lansing Police Department?
Yes, ma'am.
And did you have a valid license to display for them?
No, ma'am.
All right, and at this time, do you have a valid license?
No, ma'am.
All right, Your Honor, I have no further questions.
Any questions from you, Mr. Staples?
Nothing from the city, Your Honor.
I'm satisfied with the factual basis. I'll accept your plea. Find your plea to be made freely, voluntarily, and intelligently. You've been in custody since the time of your arraignment on this. I'll credit your time, sir. You're all set.
Thank you, ma'am.
Thank you. Okay, let's see. Oh, that was on the. Which one did you want? The other one was dismissed. The stop sign. The stop sign was dismissed, yeah. Latonya Polite failed to appear.
Your Honor, I show that through VineLink, she was transferred from Ingham County Jail. I know that she had a hold in Indiana. I suspect that they might have picked her up on that.
Interesting. This has got to be one of the oldest files of history. So, how about this? Start the trial. They can get their witnesses here. Okay. On the record, in the matter of the people of the city of Lansing versus Matthew Austin Colberg, file number 23-00192. Appearance for the record.
Matt Staples for the city of Lansing.
Michael Anderson for the defendant, Mr. Matthew Colberg, who does appear personally and to my right.
Okay, today's date and time set for a motion hearing for a motion in limine. We did have a motion in limine filed by defense counsel. There was a response filed. I'll let you proceed with your motion.
Thank you, Your Honor, and I apologize. It was filed yesterday. Did you receive a copy of our reply?
I received it, but I received it today while I was on the bench.
I understand. Your Honor, for the most part, we would rely on our motion. However, it is our belief that any evidence of injury in this matter on a simple reckless driving is not one relevant to the charge. And if this court does deem it to be relevant, it is unfairly prejudicial under 403. Simply put, the statute itself, reckless driving, is not an outcome determinative statute. Namely, it's about conduct. At no point in time does it.
Your client can be seated, sir.
Nowhere in that statute does it indicate that the prosecution must prove injury. In fact, they do not have to prove it. Rather, it is about whether or not Mr. Kohlberg's conduct was willful and wanton. And that willful and wanton conduct was a disregard for the safety of persons or property. Your Honor, the case that the prosecution cites in this matter is People v. Aldrich. Should be noted that People v. Aldrich is a second-degree homicide matter. It is also a manslaughter matter, both of which are outcome determinative statutes. Namely, they require proof of injury, in that case, death. Importantly, the court in that matter ruled that evidence of a collision was relevant to the issue itself. However, it was evidence of damage to that vehicle. It did, however, note that photographs of the victim were relevant. However, again, this was a incident in which an individual had died and the defendant was charged as such. The case that we have found, while it is a unpublished opinion, it does go through Aldrich. That is People v. Helmode, 2014 Westlaw 1510091. And while it's obviously not binding authority on this court, I do believe that it is instructive on how this matter should be handled. In that case, Judge, an individual was charged with reckless driving, even though an individual had died as a result of that collision. They were not charged with the individual's death by any means, which is a simple reckless driving. Court did find that photographs of damage to the vehicle was relevant to the matter. However, they found ultimately that photograph involving the individual's dead body was unfairly prejudicial under 403. While I certainly understand there's a difference between a dead body and injuries in this matter, which would likely include at least a broken, I believe it was a broken arm that was displaced. What Helmut says is that the damage to the vehicle is in fact relevant. It makes no mention of injuries. In fact, either does People v. Aldrich. Importantly, the other case that the prosecution notes is People v. Delgado, which is a drug matter, in which the prosecution cites for the principle that a jury is entitled to hear the full, complete story. And they say that this should allow them, the jury, to hear evidence of injury. However, the quote that they use is, "It is the nature of things that an event does not occur singly and independent, isolated from all others, but instead is connected with some antecedent event from which the fact or event in question follows as an effect from a cause." However, what they leave out at that point is that when such is the case and the antecedent event incidentally involves the commission of another crime, the principle that the jury is entitled to hear the complete story ordinarily supports the admission of such evidence. Judge, People v. Delgado is a case involving a heroin deal and whether or not the jury should be able to hear about another previous heroin deal. It's not relevant to this proceeding. Further, Your Honor, even if this court does find that it is relevant under 401, it should be excluded under 403. Like I said, this case is about any conduct by Mr. Colbert. It's not about the outcome of that case. What the prosecution seeks to do is to bring individuals in who are injured as a result of this collision, who would be able to provide limited probative insight into what actually occurred, and have them tell about their injuries in order to elicit sympathy from the jury. For that reason, Your Honor, I'm asking that this any evidence of injury be excluded.
Thank you, Mr. Staples.
Yes, Your Honor, under 401, I would like to state as a preliminary matter, citing People v. Aldrich and the general statement in law that a prosecutor need not confine his argument to the blandest of all possible terms and has wide latitude and may argue the evidence and all reasonable inferences from it. That being said, a piece of evidence is relevant if it makes any part of consequence more or less possible. The statute in question requires the driver to operate in a willful or wanton disregard for the safety of others. In the case, the unpublished case cited just a second ago by defense counsel, People v. Hemhold, the court indicated that the standard for willful or wanton behavior should be referred to from a case, Jennings v. Southwood, a published case from the Michigan Supreme Court. In that case, the court said that it is in the concept, the notion that in the circumstances of a given case, the injury is probable or to be expected or likely, that is found the requisite indifference to harm tantamount to a willingness that it occur, if not a specific intent that it does, which distinguishes willful and wanton misconduct from ordinary negligence. Your Honor, there is, I think it is fair to say that an injury actually occurring is the most probative evidence of the fact that the behavior was likely to create an injury. And in this matter, therefore, the injury is relevant. It shows the end results of the defendant's behavior. However, even if this court were to find that it is not a necessary element, that evidence is admissible if it happens to throw light on any material point. That is also from Aldrich. The jury has the right to know the whole story. Again, that is citing from Aldrich, and in direct, it said, a jury is entitled to hear, quote, the complete story of the matter and issue with a link of cites. And the court continues to say, it would have been perplexing to the jury to learn that a violent two-car collision had occurred, but not what became of the occupants of one of the vehicles. Again, Your Honor, the jury, it is clear, has a right to understand the full story. Moreover, our victims are witnesses to what happened to them in their vehicle. It is part of their testimony, and for the court to hold them short of saying a car landed on top of us without them then explaining what happened because of that would leave the jury asking questions, as the court in Aldrich so eloquently pointed out. As far as the Rule 403 prejudicial evidence, one of the defense counsel's last point is that our witnesses would have limited probable evidence or insight. The car landed on them. That is the ultimate result of the behavior, and very indicative of recklessness. Furthermore, to cite the case of People v. Baskerville, Michigan Rule of Evidence 403 is not intended to exclude damaging evidence because any relevant evidence will be damaging to some extent. Additionally, the prosecution is not obligated to use the least prejudicial evidence possible, citing People v. Fisher, 449 Mich 441, and the unfairness of potentially emotionally inflammatory evidence is mitigated when the proponent lacks any less prejudicial way to establish a critical issue. Again, it would be the people's belief that there is nothing more probative of a behavior's likelihood to cause injury than the fact that that behavior actually caused an injury. And that is part of the inquiry into whether behavior is willful or wanton, as explained by the court in Jennings. Furthermore, this 403 matter is somewhat premature, as no witness lists or exhibits have been provided to either defense counsel or the court. In the case, the unpublished case of Helmid, they were protesting the video or a photograph of a dead and lifeless body. In the case at bar, it would merely be the individuals who were in the car testifying about what happened to them in the aftermath of the accident. People have no intention of calling medical experts or anything else to extensively opine on their injuries. It is merely the conclusion of the story being presented to the jury, that it will be the individuals themselves testifying that the defendant's car landed on top of me and this is what happened because of it. And for those reasons, I believe that evidence should be admitted.
Thank you, Your Honor. Your Honor, again, what I would note in People v. Aldrich is that while there was certainly, Judge, any of the cases that the prosecution has provided to you are not on point. At no point in time do they say that evidence of injury is low. What they do say is that evidence of photographs or evidence of a collision is low. In People v. Helmuth, at issue there was whether or not evidence of injury, in this case death, was allowable. Now, the photograph was deemed relevant, and it was deemed relevant according to the court in that case because it showed damage to the vehicle. They determined that because it showed evidence of injury, evidence of death in that case, that it was not admissible under 403 because it was there to inflame the jury. Again, while I do understand the prosecution's argument, reckless driving is not a result-based statute. If an individual was drag racing and no injury had occurred, they could still be charged under a reckless driving statute. Your Honor, for these reasons, I'm asking that the evidence be excluded. If you have any questions, please let me know.
Thank you. The issue at hand would be the elements of the jury instruction. Reckless driving states here, Michigan Jury Instruction 15.14, that the city or the prosecutor would need to prove at the time of trial the following elements beyond a reasonable doubt. First, the defendant drove a motor vehicle on a highway or other place open to the public or generally accessible to motor vehicles, including any designated parking areas. Second, that the defendant drove the motor vehicle in a willful or wanton disregard for the safety of persons or property. Willful or wanton disregard means more than simple carelessness, but does not require proof of an intent to cause harm. It means knowingly disregarding the possible risk to the safety of people or property. The city is argued that they believe the injury is relevant, and that they find it to be probative, but Mr. Staples, you did mention it both in your brief or and also here today more than one time that you believe the best way to show an injury was likely to occur was to actually show an injury. I don't see how that's an element here. How is that relevant?
Your Honor, in defining willful or wanton behavior, the court in Jennings v. Southwood said that it is this in the concept, the notion that the circumstances of a given case, the injury is probable or to be expected or likely, that it is found the requisite indifference to harm. The people's standpoint is that there's nothing that shows that a injury is likely to occur more than an injury likely occurring.
You don't have to show that an injury was likely to occur in this case. It's not an element.
That's what the court defines as the definition of willful and wanton misconduct.
In that particular case that you're citing, it was a reckless driving case?
This is, I believe it was the reckless operation of an ambulance. But the court goes on to say, and in the People v. Helmwood case, that is what the court points to, which is a reckless driving case, as the definition of wanton behavior. Wanton behavior is behavior that exhibits a disregard or indifference towards the consequences of one's actions. See Jennings v. Southwood.
Okay, because one thing that is to be distinguished is that this is being charged or has been charged as a reckless driving and not a reckless driving causing serious body impairment or injury. So that is why that would not, in my opinion, be something that is relevant to the elements. I think it could have some probative value, but I find it to be prejudicial because it's going to, as stated by the defense counsel, inflame the jury. The city and the prosecution can meet the elements without showing any injury by the mere fact or the statements stated here. The vehicle drove on top of another. The focus should be demonstrating that that wasn't negligence, but it was recklessness. Injury is not the concern here. It's distinguishing recklessness versus negligence, and that he drove with a willful disregard. That's where the focus should be. I think that the evidence that should be admitted shouldn't be something that would confuse a jury or that would inflame the jury. I think that it could potentially have some relevance, a probative value that is, based on what you're saying, but I find it to be prejudicial. And so for that reason, I'm going to grant the motion in limine. And so evidence as it relates to injury would not be admissible to the jury at the time of the jury trial. Would you provide an order?
I did not, Your Honor. I can have it to your office later.
Okay, we'll get that under the 7-day rule. Any additional matters on this file for the record?
Nothing for the city, Your Honor.
No, Your Honor. Thank you.
You're all set.
Let's please.
He's on here. His name just needs to be changed. Who's in the jail? Who's in the jail?
Can't hear you.
What's your name?
Kelly Witt.
Okay, Ms. Donnelly, do you need to speak to him?
I do, with Miss Ball in a breakout room. But I am ready to go on Mr. Dupard if, Miss Ball, if you're comfortable with just handling Mr. Witt by yourself.
Okay, can we put them in a meeting room? And then on the record in the matter of the people of the city of Lansing. Oh, we are made Mr. Staples, so I guess we're not on the record yet. You went back upstairs. Okay, let's see. Do you want to be put in the room with your intern now?
Is she in one?
I believe so. Let me see. Nope, and two.
Okay, yes. Your Honor, believe I need, Ms. Ball is requesting me in the breakout room with, Mr. Witt.
Oh, I did, we didn't put her in room two.
Thank you.
There you go.
You wait.
Yeah. Okay, let's see. Did Mr. Dupart return?
Yes, ma'am.
Okay, very good. We're on the record in the matter of the people of the city of Lansing versus Trey Dupart, file number 19-043230M, council appearance.
Mr. Staples. He looks frozen.
He's not frozen. Mr. Staples? He's definitely moving. Mr. Staples, can you hear us? Hello, Mr. Staples,
Oh, there we go.
can you hear us?
Oh, can people hear me now? I've been having some
We can hear you.
Okay.
Yes. Okay, we need your appearance on the record for Mr. Dupart.
Matt Staples on behalf of the city of Lansing.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Trey Dupart, who is appearing separately by video.
Thank you. Today was the date and time set for a pre-trial. Hinder, obstruct, oppose an officer. How are we proceeding?
Your Honor, there was an offer, I believe back in 2019 to an attempt on this. I haven't confirmed with Mr. Staples whether that's still a valid offer, but either way, I believe Mr. Dupart wants to plead today.
If such an offer was made in the past, Your Honor, the city would stand by that offer.
Okay, so he wants to plead to an attempting or hinder, obstruction, oppose.
Yes, Your Honor.
Can you raise your right hand, sir? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, ma'am.
Thank you. To put your hand down. Mr. Dupart, you have the right in this matter to proceed to trial, and you have the right to a jury trial at the time of the jury trial. You have the right to the presumption of innocence. So you're innocent until proven guilty, and you have the right to require the city to prove your guilt by proving each element of the charge being brought against you beyond a reasonable doubt at the trial. Are you willing to give up those rights?
Yes, ma'am.
You have the right to cross-examine, question, and confront any other witnesses in court that the city intends to call against you. You have the right to call your own witnesses or present evidence at trial that you believe further a defense to the charge being brought against you. And you have the right to remain silent at trial and not have silence be used to prove or imply that you're guilty. Are you also willing to give up those rights in order to plead to the amended charge?
Yes, ma'am.
Is anybody threatening you to get you to waive your rights and plead guilty?
No.
Any promises being made to you in exchange for a guilty plea?
No.
And are you currently on probation or parole?
No, ma'am.
Okay, understand that a guilty plea could result in a conviction that you may need to report to your employer. You may need to put a conviction on a future job application.
Yes, ma'am.
Okay, also, you understand that a guilty plea could have impact on any travel or immigration status you may be seeking?
Yes, ma'am.
Are you entering a guilty plea to the amended charge because you believe you're guilty?
Yes, ma'am.
Okay, as to the amended charge of attempted resist and obstruct an officer, how are you pleading, guilty or not guilty, or standing mute?
Guilty.
Factual basis, please.
Thank you, Your Honor. All right, Mr. Dupart, on October 11th of 2019, were you at a location at or near 316 East Michigan Avenue in the city of Lansing, Ingham County, state of Michigan?
Yes, ma'am, I was.
All right. And at that time, were you detained by a Lansing police officer in the performance of his or her duties?
Yes, ma'am.
All right. And while in the performance of their duties, did you attempt to hinder, oppose, or obstruct them?
Yes, ma'am.
All right. And you attempted to hinder them by trying to run away, right?
Yes.
Okay. All right. But you were unsuccessful, correct?
Yeah.
Okay. All right, Your Honor, I have no further questions.
Any questions from you, Mr. Staples?
Nothing from the city, Your Honor.
Court is satisfied with the factual basis. I'll accept your plea. I find your plea to be made freely, voluntarily, and intelligently. Ms. Donnelly, you can make allocution.
Thank you, Your Honor. I know that on multiple times, or there were, multiple times that he was, I think, had a failure to appear and had to sit on this. I believe he also has, he had to post the last time he was in jail, $50. So he is currently on that out on that bond. Otherwise, Your Honor, we just, if there was going to be fines and costs, we ask that any fines, discretionary fines, be waived given his indigent status. Thank you.
Did you turn yourself in on the bench warrant? Or were you picked up?
No, ma'am. I was arrested. They took me in on warrants.
Okay, and the original date of the offense, were you arrested?
Yes,
on that
ma'am.
date as well? Okay, I'll credit your time, sir, if you're all set.
Thank you so much, ma'am.
You're welcome. Evidence we did not see. Is Kelly Witt there? Kelly Witt? They're having some kind of technical issue in the jail today because can't be 3 in a row. Okay, Mr. Levine?
Yes, Your Honor.
Okay, you're here with Mr.
Reeds, that'd be Blaze Reeds.
Reeds. Okay, let's see here. On the record in the matter of the people of the city of Lansing versus Blaze Anthony Reeds, have file numbers 23L 2789, 271, and 272 appearances for the record.
Matt Staples for the city of Lansing.
Thank you, Your Honor. Attorney Bernard Levine on behalf of Blaze Reeds, and we're both present via Zoom.
Okay, today is the date set for a explanation hearing on a no proof of insurance and a traffic device. This will be a traffic control device. How are we proceeding on these?
Well, Your Honor, I'd like to talk to the CA if I can for a bit to see if we can get a resolution on the matter. I haven't had a word with him yet.
You're in front of me, Nero. Where's Leasia Armistead? Let me talk to her. Let's see.
Your Honor, I don't believe Liège is in custody. I know that Mr. Lee has tried to contact her and been unsuccessful. Your Honor, to make it easier, I know that Mr. Witt we are going to set the hindering and opposing for a jury trial.
Sounds good. Do I have a file? I do. Okay, July 18th at 8:15.
All right, thank you.
No problem.
Your Honor, I believe we have, did you have Miguel Martinez called yet? I think that was the last one at 11 in Leasia.
I have not called either, but neither of them are here. Let's see.
And Martinez, we haven't been able to get contact. His phone is disconnected, so.
Okay, what's your bench warrant? And then. Armistead, did she have a court date coming up?
She does. I believe she, well. Oh, well, one of her felony case was completed out, so I don't see when that's set for.
Pre-trial July 10th. Is her next, is her next court date? But that's a city matter, I mean, state matter. We're gonna reset this because she's getting her court dates confused.
Okay.
Set it. Yeah, that same day. Okay. July 10. Okay. If the city is going to give an offer on this and they put it on a plea sheet and sign it, we can have them come down and address it if necessary. Otherwise, I just don't want to bench warrant her because she always mixes up her court dates.
Yep, I appreciate it. Thank you, Your Honor. I don't know what happened, Mr. Witt, but I believe that is all for us.
That is all. We just reset him for trial, right? So we're good.
Okay.
All
right.
sounds good. Thank you.
Thank you.
Are you ready to proceed?
We are, Your Honor. Thank you, Your Honor.
Okay, on the record in the matter of the people of the city of Lansing versus Blaze Greets, how are we proceeding?
Thank you, Your Honor. So the CA and I talked, we're going to do a one-on-one and my client's going to accept responsibility for operating a vehicle without insurance at the time. And I believe that's MCL 257.328 sub 1.
No proof of insurance?
That's
Okay.
correct, Your Honor.
Mr. Reeds, that's correct. You're gonna accept responsibility?
Yes, Your Honor.
Okay, your fine is $145. When can you pay?
I can pay this week, actually.
Okay, I'll note that you'll make payment within 7 days. You can make payment on the court website. You'll just use your citation number. That's the citation that ends in 271, okay?
Okay.
Or you can come up and make payment at the criminal traffic window or mail check or money order with your citation number. Do you have any questions?
No, Your Honor.
Okay, any additional matters for the record?
Not from
Nothing
us,
for-
Your Honor. Thank you very much.
Nothing for
Thank
the
you.
city,
You're
Your
all-
Honor.
Thank you, you're all set. Tell Ms. Donnelly if she forgot about Mr. Bonds. Feel free to go, Mr. Reeds.
Which case are we waiting on at this point?
Jordan Bonds.
Okay, thank you.
Mr. Staples, Judge just said that we'll do the pretrial in the afternoon, so like around 1:30.
Okay. All right, thank you.
You're welcome. Mr. Witt? Mr. Witt,
Yes.
you're all set. Your attorney said that we're just gonna leave your matter set for jury trial. And the jury trial is set for July 18th at 8:15.
Thank you.
You're welcome.
Are y'all done? Yes. All right, give me 1 minute.